Welcome everyone. Those of you on the call have likely worked with us previously, but for those that haven't, we are a management consultancy. We have over 25 years of experience. We've helped over 2,000 businesses of all ranges of industry to expand or scale in the UK. We do offer a 5 departmental offering. So we have our virtual office, governance, HR, who are here today, payroll and finance. Next slide, please, Nancy. And as Nancy alluded to, there are the 3 persons from HR today. So there's myself, who's the head of HR, and then there is Helen and Emily in my team, who are both HR advisors. And so we'll be guiding you through the session today on all things employee exit. So I'll hand off to Emily in a sec, but as a general overview, we will be looking at the employment law updates. Some of you on this call will have heard from Helen and I across the last 12 months of all the various changes that our UK government are implementing, but we'll also be guiding you through on a high level through resignations, failed probations, disciplinaries, performance, redundancy, settlements, and then also awards that have been given at tribunal. So Emily will be giving us an overview of that for effectively what could happen if it does go wrong. So I will now hand off to Emily.
So just to cover off some of the employment law updates that we should have on our radar for over the next year or two. With the new bill, the employment bill that's coming into place, we're looking at having protections from unfair dismissal from day one. So this means that employees will have the right not to be unfairly dismissed from their first day of employment. And this is opposed to the 2-year qualifying period that we currently have the luxury of. The 2-year qualifying period is going to be going. The government are looking at linking this to probationary periods for employers to be able to assess the suitability of new hires. And you'll have a lighter touch dismissal process during that probation period. And it doesn't look like this is going to be applying to redundancy dismissals. So just for your information, the current 2-year period, employees can't bring claims of ordinary unfair dismissal unless it's linked to a protected characteristic. And Helen will be touching on this later on. With probation period changes, there's going to be the removal of the 2-year dismissal qualifying period, and this is going to be replaced with a new statutory probation period, which is going to be called the initial period of employment in the bill. The length of this period is yet to be confirmed, but we're looking at about 9 months. And this isn't going to be coming into place until autumn 2026 at the earliest. We don't know what the probation period is going to be looking like or what the process is going to look like, but it's likely to be a watered down version of the ACAS process. And I think Jacqui is also going to be touching on this later on. So with the current legislation, this means that employees are protected from day one, but only relating to claims of discrimination or whistleblowing. But moving forward with the new bill, it's going to be day one for everyone. And I'll touch a bit more on the stats for this towards the end of the presentation. And I think we're moving on. Is it Helen? Helen next? I'll hand over to her.
Thanks, Emily. So I want to briefly run through a piece about resignations. So first of all, resignations aren't always a bad thing. It might be time for the person to move on. You might want to get some new ideas and new thoughts and new people within the business. So it's not always a bad thing that people want to leave and move on to a different position. You might also want to think about more widely what's happening. So with this person or people that have resigned, have they raised any grievances? Are there any underlying issues that you need to think about? And if there are, then you need to be asking some more questions and delving a bit more deeply in terms of what's happening and the potential risk to the business. Could this be contentious? So if they have raised any issues or grievances, what's the risk to the business? Could they claim unfair dismissal or discrimination further down the line? And also, it's really important to talk to the employee. So to understand why they have resigned and take that feedback. But also you need to be following up in writing to them to confirm the arrangements with them. So what's their last working day? What do they need to do during any period of handover? It's really important to put that in writing. And then we need to think about what to pay. So contractually, they will have a notice period due to you. So you would either need to talk to them about them working that notice, or you might have options in your contract to pay in lieu of notice, or to talk about garden leave if you don't want them to go and work elsewhere straight away, but you don't want them to undertake any work for you. You also need to think about, is there any additional payments due? So are they due any commission or bonus? Do they have a share scheme plan? What other payments would be due to them on their last working day? You need to look at holidays, what they've accrued up until their last working day, and how much they've taken, and if there's anything due to be paid in that respect. And also looking at benefits. So benefits would normally run up until their last working day. So you need to make sure that you're still honouring those and taking them off once they've left too. There's a whole piece to talk about if someone refuses to work their notice. So they've handed in their notice, they want to leave your business, but they're refusing to do any work. And there's various different options you can think about at that point. So I think one thing is to think about why they are doing this. Do they want to be released early so they can go and work for a new employer straight away? And if that's the case, if they come forward and ask to be released early and you're happy to release them, then you can agree to do that. And you would only need to pay them up until that last working day. But there's also other options. So if they are refusing to work, or if you don't want them to work any longer within the business, you could look at pay in lieu of notice to them. So that would mean paying them a lump sum for any remaining notice in their last pay. Or do you have the option of garden leave? And that means that they are still employed by you and they're not able to work elsewhere, but would continue to receive payment until their last working day. It's also important to think about any patterns. So are there any patterns of resignations? Is it within a particular group of people, particular line manager, particular department? What's happening there, and unpicking that a little bit more. You also might want to think about exit interviews. So interviewing those that are exiting to gain some feedback, and we can support you with those if you want us to. And also we get often asked, and what else do we need to do kind of outside of the HR process? So it's important to remember to gather any equipment that they might have of the businesses, and also to turn off any access that they have to emails or any other systems. So it's important to do that on their last working day too. And I will hand over to Jacqui to talk about the next section.
Yeah, thanks, Helen. So as you already heard from Emily, she talked about changes to UK legislation, which is incoming in next year in autumn 26. We will see day one protections, including from ordinary unfair dismissal. And this will, of course, affect terminations during probation. So as a UK law stands today, as Emily touched on, we do enjoy this 2-year limit for employees to work with continuous service of up to 2 years without being able to bring a claim against their employer unless their exit can be linked to some discriminatory or whistleblowing period. During probation, absolutely employers should be running a fair probation process to give fair assessment of employee performance and company fit during that time. And really the main take home from this section anyway will be that being able to demonstrate via documentary evidence that a fair process has been run. And what we mean by that is regular one-to-ones, formal meetings, because we do need to always bear in mind that even at the moment, there is still potential for certain people that they might try and claim that any such exit, if you haven't done those things, could have been discriminatory if they have a cause or a means to be able to take you to court. We are absolutely expecting that from autumn 2026, we will be seeing a rise in ordinary unfair dismissal cases, and we might be seeing a decline in discrimination allegations, because there is this route to be able to take employers to court. So if you haven't been able to demonstrate a fair process even during probation time, then that could really be problematic for you. So if we think about, for now, even if we, irrespective of the ethics of not following a fair and supportive probation process within a business today, it will absolutely be in the best interests of companies in the UK from next year from a legal angle. So it's really important to start thinking about putting processes in place now and training your managers so that they know exactly what's expected of them and what they need to do to be able to demonstrate this fair process. So as Emily mentioned, we don't know what the autumn changes next year will look like exactly. But from our conversations with employment lawyers in our networks, and from what's being debated in Parliament, we do expect this to look like a watered down ACAS process, for that to be a mandated process next year. And we are expecting that there will be a set period of 9 months probation. At the moment, it's up to the employer what they choose to set as a probation period, and quite popular durations right now tend to be 3 months or 6 months. So that will also be a change. Managers will be expected to meet with employees regularly for both informal and formal milestone meetings. So again, we don't know how this would look, but it seems sensible. And what we advise today is that it is best to maybe have a 1 month check-in for a formal meeting, maybe a midpoint check-in for a formal meeting, and then of course an end of probation meeting. So in any process that would be seen as being reasonable and fair. And for your informal meetings, maybe weekly or bi-weekly informal one-to-ones with the employee's manager to discuss their progress, any issues, and also to offer and demonstrate support, which is quite a key thing, support and training to be able to demonstrate that you have set that person up for success from the beginning before you've made a decision to terminate. So there will need to be clear evidence that unsatisfactory performance exists, or that there has been poor conduct during that period, and maybe the employee isn't a good company fit. And of course, as Helen did mention in her part about resignation, ultimately when you are ending an employment, there does need to be a letter to exit setting out the arrangements for such an exit. So, of course, you need to satisfy contractual obligations when you're arranging exits with an employee. So that will be looking at things like their contractual notice period, which is usually shorter during probation. But that, again, would be contractual. You need to make sure your contracts are up to speed with that. And also that your employees are being paid any accrued but unused holiday. So as Helen did mention a little bit earlier on, in terms of how that notice period can be spent, can be up to you as an employer. And again, you'd be relying on your contract for that, but there are options on how that can be spent, as well as the duration. But one thing that I did want to note, which Emily did touch on as well, is that sometimes we are approached by employers to ask if employees can be terminated by failed probation when actually they're running a redundancy round. And actually, this sort of exit is quite unfair on the employee, because it would imply that there is a fault on the employee's part for failing their probation when a company chooses to do this. And really, it's not really the ethical, moral thing to do. And as it stands, companies are relying on the current 2-year period that we have of employees being unable to bring an ordinary unfair dismissal claim. But as outlined, from next year, that will not be an option. So really do take this into consideration, that your employees who are going through probation periods will need to be consulted with on redundancy, just the same as the rest of your employment pool, and they will need to be fairly selected and so on. So Helen will be talking about that a bit later. I just thought that was an important point to note. I'll pass to Helen now. She's going to talk to you about disciplinaries.
Thanks, Jacqui. There's definitely a theme throughout lots of what Jacqui and I and Emily will be talking about, and it really is to follow a proper process. So it's really, really important through the disciplinary process to follow the right steps to make sure that you're protecting the company and it's a fair process, and that you're giving the employees all the rights that they have and the protections they have through UK law. And I know we've talked already about the lots of changes that are happening next year, but something you can do right now is to look at, do you have a UK policy for disciplinary and grievances? And if not, then you really need to be putting one in place that covers the current UK legislation and obviously anything that changes next year. And we've already touched on making sure things are fairly run and having a fair process. So first off, to look at the investigation. So what are the allegations and how are they being investigated? And from the outset, you need to think about who is conducting each of the different steps. Ideally, it's a different person that touches the investigation, the hearing, and the appeal, depending on your company size, but that's the ideal. So the investigation might look like interviewing witnesses, gaining witness statements from other people and the person that has the allegations in terms of what's happened. It might involve looking at email exchanges, CCTV, rota information. There's a whole raft of things that you can look at, but it's really important that it's a fair process and that it's investigated properly. And then the investigating officer would then decide what happens next. And if that's then to go ahead with a hearing and a formal meeting, then the employee needs to have enough notice to be able to attend that, and they must be given the right to be accompanied. We get lots of questions about what that means and who people can bring along to those meetings. And we really do suggest that it's either a trade union rep or another employee. So it's not their neighbour, their friend, their partner, their brother, their sister. It's either a trade union rep or someone else within the business. And during that meeting, it's important to think about what questions you're going to ask, what the allegations are, and what information you need to ask in order to determine an outcome. You might want to think about, the practical steps. So where is the meeting being held? It doesn't have to be held in person in the UK. It can be done remotely, but it's really important that it's a private space and that you have enough time to undertake the hearing in full. There's lots of questions and potential outcomes. So what happens if they don't turn up or if it's delayed? And we can help and support you in those sorts of scenarios and best practice of how to move forward there. And it's also really important to not deliver the outcome at the end of the hearing. Take your time to consider what's been talked about and what evidence has been presented. Have they called any witnesses? What's the description or the reason from the employee and against the allegations? So take your time, but make sure that's appropriate. It should be a quick outcome, but you shouldn't rush it. And then as Jacqui's already said, it's really important to follow things up in writing. So you need to follow up in writing back to the employee about the outcome and give them the chance to appeal. If they do appeal, there's a whole recommended practice in terms of what that looks like, who should hear the appeal, having an appeal meeting, really important, and then delivering the outcome from there. So I think the key take homes from here are following a proper process and a fair process. So making sure that there's a proper and full investigation, the hearing, and then the chance to appeal, but also looking at what you have at the moment. Do you have a UK policy? And if you don't, you really need one. But also if you do have one, that will need updating and reviewing come next year with the new legislation coming into play. And I'll hand back to Jacqui for the next section.
Thanks, Helen. Okay, so in terms of performance, I think the key take home of this whole session, I suppose, is really please do follow a proper process and make sure that you can demonstrate in writing is if you take anything from this session, please remember that. But performance is no exception. And really you need to remember to start your performance processes in a timely manner. Performance procedures or performance improvement plans, PIPs as we call them, can be really lengthy, or they have to be lengthy in order to be fair. As a HR team, we see time and time again that companies approach us. It turns out that they've let poor performance slide for a sizable amount of time, and they've never addressed it, or maybe if they have, it's been on in a very informal basis, but not in a legal manner that a tribunal would see as being supportive and fair. And at that point, when they're speaking to us, they're looking to maybe terminate that person, and we need to give the news that actually this is a bit unsafe to do, and they do so at their own peril, at the risk of being taken to court. So I guess the key is time, hitting that and communicating poor performance in the right timescales. Think about whether there are any mitigating factors as to why performance may be poor. So how well do you know the employee and what's going on in their life? Do they have any health issues that you should maybe be aware of? Are there any disabilities that you maybe need to be aware of? Which needs to be taken into consideration. Have there been any contentious matters or stresses that you're aware of? All going to be key things that a tribunal would take into consideration if someone is exited by way of performance. But going back to a process, it's really vital that the employee is aware that they're not meeting standards, and that their manager who is supporting in this can demonstrate and communicate this clearly to the employee and offer the support and the guidance that they need to try and get them back up to speed. It's best to do this informally initially, to identify, again, if there's anything else that you should be aware of that the employee may need to disclose, and then monitor progress from there. If there are any health matters or any disabilities, we would recommend that an occupational health meeting is arranged to assess the matter with the employee, and then that practitioner can offer advice and support. And if there are any reasonable adjustments that the company could consider implementing, the key thing is there that you are not mandated to implement any adjustments that they suggest. But if they are reasonable for a company of your size, then it would be unreasonable if you didn't actually make those considerations. If after that point performance is still below par, then an informal performance improvement plan should be implemented. So together with the employee and their manager would put that together, and they would agree on smart objectives, which are fair and which encompass clear targets. And also, again, if there are any reasonable adjustments to be accommodated, then those would be implemented as part of the PIP as well. A fair period for this informal stage alone from implementation to end would be 3 months. And at that point, if the employee is still not performing, then it would be necessary to invite the employee to a formal meeting to discuss their PIP performance, where they are aware of the consequences of now not meeting this formal period PIP, which could be just a dismissal. They would have the right to a companion at that meeting, and then they would roll on to a 3-month formal PIP at that point. So it's only once that 3-month additional PIP process on a formal angle has been completed that you would really be able to demonstrate that a fair process has been followed to make that decision for dismissal. And again, I'm not going to go through the payments that you would expect, but it would be the usual contractual payments, which Helen has already led us through when talking about just disciplinaries. But yeah, it's really vital to get in there early if you have a performance problem. I'll now hand back to Helen, who's going to talk about redundancies, I think.
Thanks, Jacqui. So I wanted to talk through some redundancies and talk about some of the things that you're aware of and some of the pitfalls. So I think the first question is it a genuine reason? Is it really a redundancy situation, or is it a performance, or is there something else going on? We have lots of discussions with clients about, is it a genuine redundancy, or should we be following a different process? The other thing to think about is if you make that wrong decision, it could lead to wrongful dismissal claims. So you need to be really clear and understand, Is it a genuine reason? Is it a genuine redundancy? Or should we be thinking about running a different process? The other key thing to think about is you make the role redundant. It's not about the person, it's about the role that they do for your business. So if you exit someone through a redundancy process, you can't directly rehire into that position straight away. There would be a big risk again for a wrongful dismissal claim if you backfilled into a job that was made redundant straight away. We've said a lot about following a proper process throughout these things, and there is another one to run for redundancy. So you'd need to have a look at the size of the pool of those that are at risk, not just the number of jobs that you're looking to exit, but who else is doing a similar or same job across different departments. You need to think about fair selection. So of those people, if you're reducing the size of a particular department or those that are doing the job, is it a fair selection? What selection process are you going through? What criteria are you using? And making sure that they are not discriminatory or any way or putting the business at risk. There are new protections that came into place in April last year for those that have been on recent family leave. So it's really important to look at your pool of people and to understand if they've been on any family leave in the last 18 months, and then to look at what different arrangements might need to be put in place for them. And it's also really important to have a proper consultation process. So it's not a fake process. The company is going through consultation with the employees. You need to give them enough time to consider what's happening. You need to listen to anything that they might say. You don't have to implement it, but you need to show that you are listening to them and that you've taken any reasonable steps to save these positions from being redundant. And then we've already spoken about payments and notice. So there are different options available for you at redundancy. In terms of, do you want them to work? Do you want them to leave straight away? Do you want them on any kind of garden leave? You would need to pay the pay arrangements that we've already spoken about, but there's also statutory redundancy pay that kicks in after 2 years notice, and there's a calculation that you would need to run in order to make sure that you're making the right sorts of payments if someone has more than 2 years service. I'll hand back to Jacqui to talk about the next piece.
Okay, so I'm going to talk briefly about settlement agreements. I'm just conscious of time. So we've outlined various types of exit procedure. However, there might be situations where it's maybe necessary to hold a protected conversation or a without prejudice conversation with an employee. So that is depending on the situation that you're discussing as to what's appropriate. But this in effect means that whatever is discussed under that banner in that conversation is not disclosable in court. And this could be if you're running a process for a poor performance or a particularly contentious disciplinary or redundancy process, or sometimes it can be appropriate if you're exiting a senior employee and it can be expected that is the course of action that they would leave via a settlement agreement. But effectively, a settlement agreement is a legally binding contract between the employer and the employee that ends their employment relationship in a mutually agreed way, and that they're often used to avoid long, drawn-out processes and costly legal action. So in essence, you as a company agree to pay the employee what they would have been entitled to anyway under any usual exit, depending on the process you're running, plus an additional payment where up to £30,000 can be paid as a tax-free payment as the settlement sum. And in exchange for that payment, both parties would sign a legally binding agreement where the employee cannot then take legal action against the company, aside from in a whistleblowing or harassment scenario. So this agreement would need to be countersigned by the employee's solicitor, who is a neutral party, before the agreement is legally valid. And just one word of warning here that they should be used with caution and at the right time in a process. So an employee solicitor, of course, will want to know what they're signing. They'll want to know what's happened. They will be advising the employee. And if you have done something that's untoward, or maybe you haven't followed a proper process to the point where they're advising, or they think that there's something to negotiate on, then they will, from experience. So they will try to request a higher settlement sum if you have not maybe done the right thing so far. So it is better to maybe offer such an agreement or conversation once you are so far into a fair process to limit those negotiations. And remember also that an employee can always refuse the settlement, and then you still need to then rely on continuing the process that you were running before. But that can be harder to do if you've clearly implied that you would like the employee to leave. So just bear that in mind. They can be useful, but just tread with caution. And then I'll hand back to Emily, who's going to talk to you about some awards at Tribunal over the last year.
Thanks, Jacqui. So with these changes to the Employment Rights Bill that we've been discussing, we need to be bracing ourselves for an increase in tribunals and claims. This is because it's going to be that day one right. With the move towards the day one right, instead of the 2-year waiting period, there's going to be an extra 9 million people that will be able to make a claim or bring a claim to an employer. Last year, the average award for unfair dismissal was £13,749. So this was a 15% increase from the year prior. So we are seeing a big increase in the average award price. The average award for a sex discrimination claim was £53,403, with the maximum award being £995,000, nearly £1 million. This means the discrimination claims aren't going to go away. There might be a small decrease, but they're not going to go away with the day one right. The awards are just going to get bigger because there's that added layer and those extra group of people that will be able to make these claims. We've talked a lot about following a proper and fair process in today's session, but it's important that we say that there's a 25% uplift on awards if a tribunal can see that you haven't followed a proper process. We've seen it in our own network that an employee has won a tribunal case because a proper process wasn't followed by the company, and the employee received a 25% uplift on that and was awarded £130,000 because of this. So I know we keep going on about it, but it is really, really important because you get that increase on awards. Those are some interesting ones, or ones that we find at least interesting. I think next we finish with a Q&A. Don't know if we've got any questions yet.
Thank you guys. That was great. If you do have any questions, you can use the little chat function at the bottom of your screens. But it doesn't look like we've had any through so far. I'll give that a couple of seconds. No, okay, perfect. So that's the end of this session. Thank you so much to everybody that registered and joined. We really appreciate it. If you do have any questions that come up from the session, don't hesitate to reach out to any 4 of us in the team. And that's everything. Thank you so much, guys.
Thanks, everyone.
Thanks, everyone.
Thank you.
Bye.
Bye.